Yes, counsel. Good morning.
Good morning. May it please the court, my name is Emily Cardy and I represent Mr. Suero. This case is here in this court after an application for further review after the appeals court affirmed Mr. Suero's convictions for the cognate offenses of indecent assault and battery and rape. This case is simple and it is not controlled, as the appeals court ruling stated, by Commonwealth versus Maldonado. It is instead controlled by the analysis in Commonwealth v. Howes, because that is the same standard analysis that this court has used for years when determining whether cognate offenses are duplicative or not. Mr. Suero's convictions were duplicative. The basis for the conviction for indecent assault and battery was based on the movement of the victim's shorts and underwear. And then the conviction for the rape was based on the penetration that occurred immediately following.
Was there any, did the testimony talk at all about, I don't know how, well, about any length of time between those two events? The taking off of the clothes and the actual penetration? It was immediate, unlike actually in Commonwealth versus Howes, where there was an interruption. In Howes, there was the taking off the clothes, and then there was an interruption at the door, and then a conversation, and then the defendant went back. Here, the shorts were moved, the underwear was moved, and then the act of penetration.
Moved aside, as I understand it.
Moved to the side, yes, moved to the side, and then the act of penetration occurred.
And what is your standard? Is that it is the Howes standard of being necessary to the crime and incidental to it, or is there a different standard that you're suggesting?
I think that, well, first the standard is whether is the St. Pierre standard, which is that are the acts so closely related in fact so as to constitute in substance but a single crime. And the way that a court could determine whether these are so closely related in fact so as to constitute a single crime, I would suggest there are 5 factors the court could look to, and these are factors that appear in Howes and also in Neal's N. One is the conduct continuous conduct, as it was here. 2 was the lesser incidental to the greater offense, as it was here, and also necessary to effectuate the greater offense.
So it's both, you say, incidental and necessary?
Yes.
What if, in a period of 5 to 10 minutes, the defendant first removed the clothing, then engaged in photographing the victim, and then raped the victim? Would you say the same thing?
I think one that is a different. That's a different case.
I know it's different.
And 2, the 2 other factors I was going to talk about were the intent and whether or not the incident was brief. And I think perhaps your example goes to intent. Here, in this case, it was motivated by the same in criminal intent, right? The movement of the shorts and the movement of the underwear, and then the act of penetration.
So in my case, it is too. There's just some intervening unrelated activity, or it may not even be unrelated.
I would say that perhaps then a jury could find a separate act there because you have the photography, and perhaps the photography would indicate a separate intent. Whereas here, the movement of the clothing doesn't indicate a separate intent because it happened. It was continuous conduct here.
So what's your next factor? Your last 5th factor?
The incident was brief. That the 2 acts were brief.
And you're suggesting this actually is a question of law that the judge decides. It's not a question of fact for the jury.
Absolutely. That it is first a question of law that the jury has to. The judge has to find whether a jury would be permitted to find this as separate criminal acts. As opposed to one continuous criminal act, and then obviously the factual question goes to the jury as to whether these acts occurred or not. But certainly it is for the judge to decide. And I
take it not just occurred, but if the
the judge permissibly could make a finding that they were separate, that would also ultimately then be a jury question, whether they were, not only did they occur, but that they separately occurred.
Yes, that's
Because
correct.
I suppose the jury could still find
That they were so inextricably linked that they could not be two separate criminal acts. And you can find in Commonwealth versus Sanchez and Commonwealth versus Thomas, both the court decided that the acts were so closely related, in fact, as to constitute one single criminal act. And also in Kahane, in that case, this court said that the judge may decide this issue. So it is both primarily, preliminarily, a question of law.
Now, with regard to your factors, you use the word necessary to. Is that a required factor, or are these simply factors to consider?
I think these are factors to consider and weigh.
So if the defendant in this case had removed the victim's blouse, which would not be necessary to penetrate, would you say that that's a separate crime of indecent touching of the breast area?
I would say that is similar to Kapsala, Commonwealth versus Kapsala, where the court found a number of different acts, and I would say that there the jury probably could find separate acts because the lifting of the blouse was not necessary to the rape. It is separate conduct, and I do think necessary to, particularly in this case, is an important factor, that the movement of the clothing here was necessary to the act of the rape.
Now, pragmatically, if you prevail here, the result is he has no probation.
That's yes, Your Honor.
So that would be the consequence in this case, and he'd be guilty only of a single count.
That's right. That he received 5 years for the statutory rape, and then on and after the 10-year probation for the indecent assault and battery. But even if he had received concurrent sentences, we would still be here, and that's Commonwealth versus Jones. And I want to reiterate that the St. Pierre standard, this standard that are the acts so closely related, in fact, so as to constitute in substance a single crime, is the controlling standard, and we see that as the controlling standard by this court's ruling in Commonwealth v. Vick in 2009. And that is the case that states that the St. Pierre analysis survives where there are cognate offenses. Commonwealth v. Vick deals with non-cognate offenses, but at the conclusion of that opinion, this court stated that for cognate offenses, the conduct-based analysis remains, and the St. Pierre standard remains to determine whether they're duplicative or not.
Now, have you found any case in which we have ever knocked out a claim like this where the jury was specifically asked to find facts that it was a separate act?
I think that there are two separate questions. There's a dual inquiry here. Of course, the jury has to determine whether there were what those two separate acts. They have to base their guilty finding on one act per offense, and the jury here was given that option and was properly instructed as to that. The bill of particulars was filed. The Commonwealth theory was presented to the jury in the jury verdict form, and so they knew which acts went with which criminal offenses. But the first part of that inquiry was not whether there are two separate acts. The first part of the inquiry is whether or not the two acts that the Commonwealth alleges are so closely related in fact so as to constitute in substance a single crime. And so I think that many of the cases deal with the fact that a judge has not adequately instructed the jury as to the two acts, and that the unanimity instruction. But this case is slightly different because it deals with that first inquiry, which is a legal inquiry, not a factual inquiry.
Right, but my question was, have you found any case where there was that instruction by a judge and we have overturned the conviction on the grounds that you're describing?
If you may give me a minute. Nothing comes to mind at the moment where this court has so stated.
So the closest is the dictum in House.
The closest is House, and House controls not only because it uses this court's sound analysis that has been using for years and years, but also the facts closely parallel this case. I mean, in House, it is the removal of the clothing and also and then the penetration.
Right, but of course in House there was no instruction to the jury about separate acts.
Right, but in House, the decision in House also says, but even if there were an instruction, this conviction would be impermissible, and it would be impermissible because this is a legal question, and it is a question that should not have gone to the jury.
So the exception that you're describing would actually be extraordinarily rare.
I don't.
Because it would have to be necessary to the commission of the greater crime.
I believe so. I mean, I don't know. I can't speculate as to how common this is or is not. But under the factors that we see in the case law, the continuous, incidental, necessary, and motivated by the same intent and brief, those are the factors that the judge could and should weigh before sending this to the jury.
Isn't maybe I have the wrong case, but I think it's maybe Thomas, in which there was not a separate instruction, but the court is pretty specific about even if there were, it would still be a problem?
That's right, yes. Thomas was this court's case, yes, and there was no instruction on the indecent assault and battery as being a lesser included of the rape, but yes, there the court said, but they were so closely related in fact. So
said just assuming that there had been an instruction, it wouldn't matter.
That's right. Yes, thank you. Yes, that is Thomas. Finding.
I'd like just to go back to Justice Gantz's question, because I'm beginning to wonder. You have to be careful about what you ask for sometimes. Is it your view that if in the course of a rape the defendant grabs the other person by the buttocks before there's penetration, that is that a separate crime? It's not necessary.
I would say that the standard that the sort of the 5 factors that I have presented to the court are factors to be weighed, that in determining whether it is a separate crime or not. Here, the indecent assault and battery was necessary to the rape, and I do think that is important. In your hypothetical, I would say that it would probably touch on the continuous conduct. It would be incidental to the rape, that it probably would be motivated by the same intent if it were in order to facilitate the rape, and it would be brief. And so in that sense, I would say that that it would be that same conduct and would not constitute a separate crime. And that touches on sort of if the court were to find that that these 2 acts were separate and were not part of this same continuous conduct, that it would create an absurdity, because what would prevent the Commonwealth from breaking down these offenses further? So if there were, for example, multiple buttons on a pair of pants, and each time one of the buttons was undone, that could be a separate indecent assault and battery. And or for example, if any time a murder was committed, an assault was also committed. And so to avoid that, I think that the standard is sound. It's placed in good authority, that is, and avoids the sort of absurdity in the law. I see that my time is concluding, and I would ask the court to reverse Mr. Suero's convictions on the indecent assault and battery, because they are duplicative. Thank you.
Thank you.
Good morning. May it please the court, Ron DeRosa on behalf of the Commonwealth. With me is Assistant District Attorney Michael Patton, who was the trial prosecutor in this matter. Here, both the trial judge and the appeals court were correct in concluding that whether or not the acts in this case were separate and distinct were a question of fact for the jury to determine.
If there's a murder case, a victim stabbed 15 times, and there are counts for assault and battery, 14 counts for assault and battery by means of a dangerous weapon, a knife, and then 1 count for murder, does that work?
Under a duplicative analysis, so long as the jury was instructed that the convictions had to be based on separate and distinct acts, and they were properly instructed that way, yes, the defendant could be convicted so long, again, as the jury found that they were separate and distinct acts.
What's different between this case and Howe's?
The main difference, which is what Howe's, the primary reason Howe's was reversed, was because, again, the jury wasn't instructed on the matter.
But do you agree that Thomas says there is a two-part inquiry here?
I don't know if it expressly says that. It says moreover, and then it refers to the St. Pierre case with the language that they're so closely related in fact. So no case has, either in the appeals court or this court, has expressly said that whether convictions are duplicative is a two-part inquiry. In the first part for the jury and the second part for the judge. The only language from this court has been that whether acts are separate and distinct is a question of fact for the jury to determine. The majority of the cases, in fact, Justice Gantz asked a question about whether or not there's a case, this court has had a case where the jury was correctly instructed and the court found duplicative convictions. I could not find a case where the jury was correctly instructed. The majority of the cases reverse because the jury wasn't instructed on separate and distinct acts, where it has been, in cases like Kapsala, where the jury's been instructed correctly, the court has said, even in the situation where lesser included offenses are at issue, separate and distinct acts is a jury question.
It's always a fact question.
With regard to the question of duplicative convictions, yes.
So that means that the Commonwealth can deconstruct a crime into as many pieces as it can prove.
Well, no, because there still would have to be sufficient evidence of separate acts.
Right, but as long as you can prove each separate act, you can deconstruct a crime into multiple crimes.
Yeah. Yes.
So would that mean that if I were to point a gun at somebody and then fire, you could charge me with assault with a dangerous weapon and also with assault and battery with a dangerous weapon, because there was that moment in time when I pointed but had not fired?
Well, again, that would depend on the evidence before the jury, whether there was evidence if he pointed and fired, if he pointed the gun and held it there for a period of time. These would all be, ripe issues for the jury to determine. And again, this type of issue is conducive to a factual determination. These issues as timing, form, and intent are issues that are within the jury's purview in the normal course of trials. So in situations like that, again, it could be argued to the jury that those were not separate and distinct crimes, that they were all part of the assault and battery. But again, it would come down to the timing and the intent or the evidence regarding those two issues.
But if you can say you could argue that to the jury, then the judge would still have to determine whether a rational jury could reach that conclusion. So isn't there still a matter of law that's left for the judge?
Well, that would be certainly a sufficiency claim, and
isn't that essentially what this is that the evidence was not sufficient for the jury to find that these were separate and distinct acts worthy of separate punishment?
It essentially is, but here we do have, here there's a rational jury, in fact, did find that there were separate acts involved. They were instructed, again, they were instructed that the convictions had to be based on separate acts.
Right. Well, I mean, I think the defendant's not challenging that well, they're not conceding, but I think, assume for the sake of the record that he did push aside the panties and then did penetrate. The issue was not whether or not there were two separate acts. The issue was whether, as a matter of law, a jury may find those acts to be viewed as separate and distinct. Isn't that sort of the issue?
Yes, and the judge here found that they were. Giving the timing, she did. There was evidence that he had pushed the clothing aside. She had said stop, and then penetrated. Given that they were, when it boils down to it, separate physical acts, a rational jury could so find.
Isn't one necessary for the other on these facts?
It is, but that's it was here in any event. Not, of course, not in all rapes, but in the facts here, he had to push the clothing aside. But again, even though it was necessary to, or a precursor to the rape, the act itself of moving aside was a different form of an act than the penetration that occurred.
Do we know how much time passed between the pushing of the clothing and the penetration?
There's no specific testimony as to that. It certainly wasn't a lengthy period of time. There was testimony that again he came in, moved the clothing to the side. She said stop. He went ahead and penetrated her anyway, and that he backed away as well. Then he backed away and then did it again.
Would you agree? Would you consider that continuous?
In this scenario, I would suggest that while the defendant was indicted for one count of rape and one count of indecent assault and battery, the fact that he backed away and went ahead and penetrated her again could theoretically we could have charged 2 counts of each, rape and indecent assault and battery.
2 counts of each because he had to push the clothes away again. Is that what you're saying?
Well, and that he backed away. That would have supported. I suggest would have supported again that two counts of penetration occur because he
but not 2 counts of indecent A and B, right?
It could have supported it.
If he's just still holding the pants, and that's
my inference from it is that he backed away, removing his hand. Now I don't know. That may not have been that may not have been the testimony, but my inference from it is that his comment that he backed away.
So the pants fell back into place.
Yes. So that's why I'm suggesting that that would have been possible based on that.
You have 4 consecutive sentences in that.
Again, that would be it would have been supported whether or not, and again, it would have been a rare case where the Commonwealth would have done that, and I think the Commonwealth was more than reasonable in this case, only indicting the defendant once for each act. But again, because it was squarely presented to the jury, and this court has held that whether acts are separate and distinct are a matter for the jury, and for the fact finder alone, the defendant's conviction for indecent assault and battery need not be vacated. And if the panel has any further questions, I'll rest on my brief. Thank you.
All right.